This isn't just immigration policy. It's a legal demolition, executed courtroom by courtroom.
And at its center, 530,000 lives. And on May 30th, 2025, the final gavel fell. 5 months, 9 rulings, 2 Supreme Court decisions, and 5 moments that changed everything.
January 20th, Trump signs executive order on day 1. March 25th, DHS files formal parole termination. April 14th, Judge Talwani blocks mass removals. May 19th, Supreme Court ends TPS for Venezuelans. May 30th, Supreme Court clears DHS to revoke CHNV parole entirely.
Tonight, we rewind the 5-month legal offensive that reshaped Biden's parole framework and left 530,000 migrants exposed.
Welcome to TFN Rewind. It only makes sense when you start at the end and strip the spin in reverse.
I'm Hope, breaking down the courts, rulings, and legal mechanics that drove every stage of the story.
And I'm Nigel, tracking Trump's executive orders, DHS enforcement moves, and the White House's full reversal of Biden's programs.
This is Trump's 5-month legal war that ended Biden's CHNV parole and TPS protections. May 30th, 2025. After 5 months of nonstop litigation, injunctions, appeals, emergency stays, the U.S. Supreme Court handed down its 6-3 decision in DHS v. Rodriguez. The Massachusetts injunction was lifted, lawful immigration status for approximately 530,000 individuals terminated immediately. These individuals had entered under Biden's CHNV humanitarian parole, primarily from Cuba, Haiti, Nicaragua, and Venezuela. The ruling stripped their legal protection under that specific program.
Inside the White House celebration, DHS Secretary Kristi Noem called it a return to lawful enforcement. President Trump posted on Truth Social, Supreme Court delivers big win. CHNV parole is over. We're restoring law and order at our borders. Hashtag America First.
Immediately, ICE began executing arrests, some occurring outside courthouses and USCIS appointments. Advocacy groups describe these as ambush arrests. Democrat Minority House Speaker Hakeem Jeffries responded, "We're not done fighting. Congress will act." 2 days earlier, Judge Indira Talwani temporarily ordered DHS to resume processing pending legal applications, including work permits, TPS, asylum, and family-based green card cases. Roughly 250,000 parolees with pending cases remain temporarily shielded. These pending applications continued through normal USCIS processing channels. For those with pending applications, such as I-130 marriage petitions, I-485 green card adjustments, asylum claims, TPS filings, U-visas, T-visas, or VAWA cases, their applications remain active and continue toward adjudication. AOC posted, "A small but necessary lifeline for those who followed the rules."
The administration immediately appealed to the Supreme Court. President Trump posted on Truth Social, activist judges are blocking our efforts to fix Biden's border mess. We'll take this to the Supreme Court and win. And he did, with a 6-3 verdict supporting his effort to undo, as Trump claims, was a Biden border mess.
10 days prior, on May 19th, the U.S. Supreme Court ruled 8-1, allowing the Department of Homeland Security to move forward with ending temporary protected status, or TPS, for 350,000 Venezuelans living in the United States. This came just days before Judge Indira Talwani issued a last-minute court block on May 28th, halting the administration's efforts to revoke TPS for these Venezuelans and other nationals. On April 14th, the same federal court judge, Indira Talwani, ruled existing TPS holders retain their protections for now, unless DHS revokes their specific case or their status expires.
Behind the scenes, DHS expanded detention capacity, repurposing military bases and surging ICE processing to prepare for higher removal volumes.
May 1st, Trump's Solicitor General, D. John Sauer, filed an emergency appeal with the Supreme Court, seeking to overturn Judge Talwani's April 14th injunction to block Trump's administrations to bulk revoke temporary protection status. The government argued that the executive branch holds full discretion over the issuance and termination of parole authority. Democratic lawmakers, including Senator Bernie Sanders, visited ICE detention centers during this time, reporting overcrowding and strained resources.
ICE arrests climbed to 3,000 daily, directly authorized by DHS in April 2025 as all this legal drama is playing out in the U.S. court system.
On April 15, 2025, the First Circuit declined to fully lift April 14 Judge Talwani's order to bulk revoke CHNV process, while granting expedited appellate review.
The White House quickly pivoted to direct Supreme Court review rather than await Circuit Court resolution.
As the April 24th deadline for self-deportation or expedited removal of TPS foreign national petitioners approached, protests outside Boston's Moakley Courthouse grew more intense in April. On April 14th, Judge Talwani ruled that the Department of Homeland Security could not revoke CHNV parole in bulk without conducting individualized reviews, based on her interpretation of the immigration statutes. This decision came in response to a March 25th update from DHS, which issued a Federal Register notice formally ending Biden's CHNV parole program. According to Judge Talwani, mass termination was deemed inconsistent with DHS's statutory parole authority under the Immigration and Nationality Act, INA, which requires case-by-case evaluation.
DHS Secretary Noem denounced the ruling as judicial overreach. In response, DHS rolled out its self-deportation option, offering $1,000 incentives for voluntary removal via the CBP1 app. Trump posted on X, "Activist judge blocks our border plan. We fight back. Deportations will proceed." On March 25, 2025, the Department of Homeland Security, DHS, published a Federal Register notice announcing the termination of the CHNV parole programs, effective April 24, 2025. This decision revoked the temporary legal status of over 530,000 migrants from Cuba, Haiti, Nicaragua, and Venezuela who had entered the U.S. under the Biden administration's Humanitarian Parole Initiative. The program, initiated in 2022 and expanded in 2023, allowed these individuals to live and work in the U.S. for up to 2 years with the support of a U.S.-based financial sponsor. DHS justified the termination by citing ongoing high levels of illegal immigration and the belief that the parole programs were inconsistent with the current administration's immigration policies.
The deadline, April 24th. Leave voluntarily or face expedited removal. Per DHS notice, non-citizens could report departure using CBP1. Those who complied became eligible for a one-time $1,000 self-removal incentive. However, self-departure may still trigger re-entry bans, typically 3 or 10 years depending on prior unlawful presence or prior removal history.
On March 25th, Trump declared, "We're revoking Biden's CHNV parole for 532,000 migrants. Leave or face deportation. America first." In response to the expected surge in deportations, DHS authorized expanded detention space and requested $2 billion in additional funding for accelerated removal operations, citing a significant resource shortfall.
February 2025, amid escalating legal battles over the termination of the CHNV parole program, Judge Indira Talwani issued a temporary restraining order halting the immediate removal of individuals affected by the Department of Homeland Security's DHS decision to end the CHNV, Cuba, Haiti, Nicaragua, Venezuela parole program. The ruling emphasized Judge Talwani's insistence on conducting case-by-case reviews rather than applying a blanket policy.
In February 2025, simultaneously, along with accelerating removal operations and requesting for $2 billion in additional funding, President Trump directed the expansion of the Guantanamo Migrant Operations Center, GMOC, at Naval Station Guantanamo Bay to full capacity, aiming to provide additional detention space for high priority criminal aliens unlawfully present in the United States. This move was part of a broader strategy to address immigration enforcement needs identified by DHS and the Department of Defense. Secretary of Defense Pete Hegseth visited Guantanamo Bay to oversee the operations, stating that the facility represented justice and deterrence. He met with service members supporting the DHS-led migrant operations and emphasized the professionalism of the Joint Task Force Southern Guard personnel involved in the mission. DHS also accelerated ICE arrest operations, focusing on sanctuary jurisdictions. President Trump took office on January 20th, 2025, and immediately signed Executive Order 14,001, restoring border security and immigration enforcement. The CHNV Parole program was immediately suspended. 530,000 previously authorized parolees under Biden's expansion faced the loss of legal status.
Advocacy organizations, including the ACLU, Haitian Bridge Alliance, and Justice Action Center, filed Rodriguez v. DHS, initiating the court fight that would ultimately reach the Supreme Court. The CBP One app, which had been instrumental in processing CHNV parole applications, was also discontinued. Migrants who had scheduled appointments through the app were informed that their appointments were canceled, leaving many stranded and uncertain about their futures.
President Trump's reaction was swift and emphatic. He posted on social media, Day 1, Biden's border policies end. CHNV parole dead. America first.
5 months, 9 court rulings, 2 Supreme Court decisions, one of the fastest federal reversals in modern immigration law, or maybe ever.
For Trump, full executive authority restored. For advocacy groups, most legal options closed. For 530,000 people, Biden-era protections revoked.
This was TFN Rewind, Trump's 5-month legal war that ended Biden's CHNV parole and TPS protections.
It only makes sense when you start at the end.
Subscribe, because we at TFN rewind what others fast forward.